and welcome to Summary Judgment.
Good afternoon.
So much has been going on here. I'm really confused. What was that thing that was just playing? Was that you talking about something?
It was inviting people to call the show.
Oh, you and your phone calls. Okay, let's start all over again. Good afternoon and welcome to AM News Network presents Summary Judgment. I'm Rachel Baird. I'm joined by Ed Peruta and Matt Tyszkka. I'm an attorney in Harwinton, Connecticut. Ed's my legal investigator and president of American News and Information Services. And Matt is a retired lieutenant colonel with the state police and an attorney. He also does a lot of other things, legislative liaison for Connecticut Carry and a member of CCDL and Oath Keepers. So here we go. Is there a reason we have the mouse sitting in prominent display for the show, Ed? We got a lot to talk about tonight, and we have an 18-minute video.
Listen, we are, if you have Skype, and you Skype AM News Space Center, if you try that, you may get us, and we may be able to do this.
Okay. Via Skype, yeah.
Via Skype. Yeah. AM News, one word, Space Center, and I don't know if this will work or not.
Does that light being off make it darker in here,
No.
do you think? No?
But I'm going to...
It looks a little dark over on my side.
I'm going to do some lighting.
Okay.
Okay, I'm going to move the lights back a little bit.
I don't have a pen on the table. I may have to borrow yours
Yes, you do.
at times.
It's right here.
Okay.
There we go.
There we go. Okay, so let me tell you what I have to talk about tonight. I want to talk about a motion to unseal documents that I filed with the Connecticut Superior Court this week that was returned to me purportedly because I lack standing to file it. I want to talk about a brief that I filed last night in the ongoing Kaminsky case, and I can explain more about that. And I want to talk about the East Haven Planning and Zoning meeting that I went to on Thursday night with Ed. So those are three things I'd like to talk about. What about you, Ed? Why don't you go next? What do you want to talk about tonight?
Well, I know that you don't probably want to get into it right now, but there's a very strange First Amendment decision that came out of the Eighth Circuit Court of Appeals.
Yep, I have it right here.
Oh, yeah. That one.
Regarding whether or not we as individuals have the right to videotape public employees, police, when we're on public property or in a public street. Now, I'm going to go this far.
Well, we're just naming our topics right now.
Okay.
So you have the Eighth Circuit case. Anything else on your
And
mind?
I'm gonna,
East Haven,
and I'm
right?
gonna join in with you on this East Haven situation because it goes further than simply Zoning Board of Appeals is having a public hearing. It goes to their compliance with the Freedom of Information Act or state statute.
Okay.
They've been following that for a while.
And any additional? That's only two? You have anything else, Ed? Well, if you think of something
Okay.
like...
Look, I'm going to
hurry
talk.
up, because Matt's going to name his three.
I'm going to talk about Trump and North Korea and Guam.
Some international
Well,
input from Ed.
Right.
Okay. What about you, Matt? I know you always bring a lot. Three things?
Well,
and they can overlap if you want or not.
yeah, the Fourth Circuit Court, it's a typical thing. A guy was stopped. The police had no reasonable suspicion. They shook him down, found a gun. They went to the district court. They said, yeah, that was good. The Fourth Circuit panel said it wasn't good. Fourth Circuit en banc said, oh, yeah, it was good. So it's another case of Terry versus Ohio being totally ignored by the federal courts. So anyway, the issue is with Trump.
And I know we'll talk more. It's another case of my argument. Screw the three-judge panels. Why don't we just have en banc panels hear our appeals?
Might as well.
Well, on gun cases.
Because if one judge is pissed off, he says, let's have an en banc.
Well, in some Connecticut courts, they have what they call gun courts, so maybe we could have gun appellate courts where everything's just heard en banc, because that seems to be the way they're treating it.
Yeah.
Okay, right. So what else, Matt?
And,
that's one?
Just a couple of comments on the Hartford gun buyback from a few weeks ago. They had a record of 207 firearms turned in, which turns out to mean nothing. And And another case of where took police over an hour to respond to a violent crime call, and people have to defend themselves
No,
against that.
whoa.
Was that in Connecticut or somewhere else?
No, that was in Washtenaw County,
Whoa,
Michigan.
whoa. This isn't a topic, but I'm just going to tell you. Somewhere I was reading where an 82-year-old gentleman got stuck in an elevator at an apartment complex, hit the emergency button in the elevator to call for assistance. The call went into the elevator company, who transferred it to the management company, who I guess called the fire department, and the fire department checked the working elevators but didn't check the broken elevator. And he was last seen on July 5th, and they found his decomposing body
you kidding.
in the elevator because people were saying there was a strange smell.
Jeez.
Now, you just got done saying it took an hour for the police to
It's
respond
peanuts.
to a violent call.
Right.
I'm saying it took a fucking month
Yeah, right.
to find the guy who pushed the emergency button in an elevator. So what I'm trying to say is equation and go like this. Cannot rely to protect us from situations 100% of the time. Whether it's
Absolutely.
police or
No.
fire or East Haven town clerk's office, the East Haven administrative assistant to the administrative assistant, we as individuals have to be on our own and on our toes and know, for example,
Well, an elevator situation, what are you going to do about that?
well, okay, let's do this.
Well, somebody
What are you
should
going to
at
do?
least
What are you going to do?
No, I mean, what could that 81-year-old have done differently to, like you
he
say,
could.
be on his
Fired
own?
his gun.
Well, if you had one.
No, but
And he probably maybe didn't have a cell phone.
truth is stranger than
I
fiction.
mean, sometimes bad things are going to happen. There's no doubt about it.
Truth is
And-
stranger. Attorney Baird, Superior Court, to give her standing that's guaranteed.
Well,
So,
what do you want to start with that?
start with
Okay.
that.
Yeah.
Okay,
Launch.
so let's start with that. This goes back to the June 4th, 2016 incident, Flatbush Avenue. Hartford police officer Sean Spell is arrested. He is represented in his criminal case in the Hartford court by the Crombie Law Firm. Now, Ed and I sued the city of Hartford and some officers for trying to prevent him from recording police activity on Park Street in September 2014 and on Kelsey Street in August 2015. The Crombie Law Firm represents the individual officers in that civil lawsuit that Ed and I have brought. I was attempting to ask Officer Barone some questions about his presence at Flatbush Avenue on June 4th. And the Crombie Law Firm lawyer objected. And I said to myself, the Crombie Law Firm is representing Sean Spell, who was arrested for something that happened on Flatbush Avenue, and they're representing police officers who were witnesses to what happened on Flatbush Avenue. That is a conflict. And it's a conflict for the Crombie Law Firm to be telling the individual officers not to talk about what happened on June 4th and not to respond to my questions, because it appears that they're trying to protect their other client in the criminal case, Sean Spell, when they're supposed to be looking out for the interest of their clients in the civil case. It's what's called a conflict in representation. It's an obvious one. So
Let me just add to that, because I need to.
there's even more conflicts than what I've said.
But I need to
We
add.
could talk hours
But
about
I
these
need,
conflicts.
for the people on the other side of the camera, I need to be able to explain something. Attorney Baird was deposing defendants in my lawsuit or individuals who were present at the time of my alleged violations. And on Flatbush Avenue, in a video clip, you can hear what we believe to be a police officer from either West Hartford, Hartford, or the state police saying, cameras, cameras, cameras. Now, if cameras are feared by law enforcement, if that cameras, cameras, cameras was an announcement to everybody, for example, hey, we can't chase the cruiser dash cams away, cameras, cameras, cameras. There's going to be cameras. When you start to ask any police officer in a First Amendment camera case about their phobia to a camera, and you want to ask them about what happened on Flatbush Avenue, that is relative to our case because he was in both places. And you're right. There's a conflict. But
and then what we subsequently learned was Officer Barone has muscle memory when it comes to turning off his dash cam camera. Those are his words, muscle memory. That was his reason for turning off his dash cam when he drove up to a scene, a crime scene. He said it was muscle memory to do that. So if he has muscle memory to turn off a dash cam, why can't we ask him questions about muscle memory in making sure that crime scenes aren't recorded, pushing away the news media, pushing away individuals who are trying to record police activity? It's very relevant.
Another topic that comes into play here. We talked, and I don't remember whether it was on the Morning Report or last week, about the Journal Enquirer making an FOI request to the Connecticut State Police for the internal affairs files on the officers who were involved with Michael Picard.
That's right.
And the state police have come out and made the statement that they're going to go on, I believe it's section 12- or 1- or whatever it is, 240. Now, when you ask for a personnel record of a public employee, the government agency is required to tell the government employee that there is a request for the record, and the employee has 5 days to either agree to have it released or to object to it being released. I have no doubt that that is the law, that is the way it's supposed to be handled.
It's a little more nuanced than that. If they believe that any of the documents in your personnel file present an invasion of privacy, were they to be released?
But Sean Spell objected to my request for his files from Hartford, and I didn't fight it because I already had them. By the time it came down to an answer, I already had them. But what I'm saying is this: there is a very long list of FOI decisions from the commission, and I don't know whether it has gone to an appellate court that says this: the internal affairs complaint, investigation, and discipline file, called the IA file, is not a part of the personnel file. It is a totally separate entity in and of itself called the internal affairs file. And because the public's right to know about misconduct, especially when there's a sustained finding, clearly outweighs the privacy rights of the employee who's had an IA sustained. Now, you know my feelings on FOI lately. They can be thrown onto the trash heap. Because in this situation, the JI should be entitled to an expedited hearing on the request for the internal affairs files because of previous commission rulings, because of previous appellate or superior court or appellate court rulings that the internal affairs files are not the personnel files that they're talking about in 240.
Yeah, I thought that was long settled.
Well, you know,
So I don't know what they're
there
claiming.
is no downside to them delaying. Now,
Okay, this is old news. Let's get back to the new stuff, okay?
let's go.
So we filed a notice to the prosecuting authority of a conflict in representation. I filed it on behalf of Ed Peruta and American News. We filed it on December 21st, 2016. And I lost track of it because I've been involved in other things, but I was at the courthouse a couple weeks ago, and I said, let me go in and look at the file and see what's going on with that.
Can I just say one thing before you go?
Yep.
I think you need to at least add this to it before everybody hears your story.
Uh-huh.
You got bounced out of a case in Litchfield County.
Yeah, well, let's...
No.
I don't want to complicate it. I don't want to complicate it.
A court in Connecticut
Okay.
evaluated
I've
and
lost it.
Okay.
I want to
Okay.
get
Okay.
going with the story. You already delved off into the freedom of information thing, and let's just get this going. So we filed this motion on December 21st, 2016, and I went into court a couple weeks ago, and I found this really strange document. It said court exhibit list, and then it had Court Exhibit 1, stricken appearance sealed, Court Exhibit 2, stricken notice to prosecuting authority of conflict and representation of defendants sealed. So the court on January 18th sealed my appearance and the notice. So in Connecticut, under the practice book, there are certain provisions for sealing documents. And, you can add in if you want. I mean, I didn't mean to shut you down. I just wanted to stay on this subject, that's all. And I think it's because, especially in family court, certain people were getting divorces and somehow their files were getting sealed so nobody would be able to go in and look what was going on in their divorce.
it
Remember
was
when
more
there
than
was a
family
scandal?
court, but you're right.
Yeah, for
Happened
example,
to John Rowland
yeah.
back
Yeah.
in the 90s.
So there were some scandals about sealing. So I don't know when these sealing practice book rules came into effect, but there's a practice book section for criminal cases, 42-49A, that sets forth procedures. The judge is supposed to articulate the overriding interests being protected with specific findings underlying the order and the duration of the order. There is nothing in the file about that. A writing signed by the judicial authority setting forth the time, date, scope, and duration of the order. There's nothing in the file about that. Could it be sealed? It's not on the sealed list. There's no order on the sealed order list, so I don't know. I'm just saying I went and looked at the file and I didn't see any of this. An entry in the court file by the court clerk setting forth the time, date, scope, and duration of the order. That's not there. A publication of the order by posting on a bulletin board adjacent to the clerk's office, accessible to the public. Nothing. An order by the judicial authority that a transcript of the decision be included in the file or a prepared memorandum setting forth the reason for the order. Nothing. And then, here's a good one. You're supposed to have a hearing, a public hearing calendared with notice given, which you see them on the Connecticut Judicial website page all the time, of a hearing on a motion or a motion by the court to seal. None of that happened in this case. Judge Dewey just ordered my notice and appearance sealed without going by any of the practice book rules.
Okay, and
Because-
to be clear, you were never notified of this.
Never
since
notified.
January.
And the public wasn't notified.
And nobody.
No.
The publication in the clerk's office, and I've seen one lately,
Okay.
and the publication on the judicial website
Uh-huh.
is because under the practice book, everyone has standing
That's right.
to address the seal.
When something's sealed, that means the public can't look at it. So the public has an interest every time something is sealed.
Joe Shit the Ragman, living in a cardboard box in New York City, in the Bowery, could come up to Connecticut and attend a sealing hearing and has standing to address the issue if he so chooses.
If he had notice.
Now, just interestingly enough, we just did a case at the appellate court related to your video taping the Patel trial up in Litchfield Court in January, where the judge said, I don't know when he said it, I don't think the appellate court was clear when he said it either, but somehow the word got to the clerk that you weren't allowed to have copies of exhibits that were public exhibits. You could look at them, but you couldn't have copies. So that's limiting the disclosure of those exhibits. And in State versus Patel, the appellate court case that just came out in June of 2017, the court said, in the present case, the court issued its order preventing the petitioner as well as members of the public from obtaining copies of certain exhibits in the absence of the petitioner's attorney and without prior notice to the public. Accordingly, neither the petitioner nor interested members of the public were afforded an opportunity to be heard. The court didn't articulate the overriding interest. In other words, Judge Danaher didn't do anything that was required under the practice book either. And we went to the appellate court and got review of that, and we won. And now it looks like the state is going to, it has petitioned for cert to the state Supreme Court for the Supreme Court to hear it.
Is ours a $40 million case? The boat case?
Yeah, I don't know. But going back to the case we were talking about, the Spell case that's in Hartford Court right now, this judge didn't do any of those things either. And so when I found out a couple weeks ago about the sealing order, because I didn't know it had happened in January, I said, well, do I appeal to the appellate court now? And then because she didn't follow the procedures, then I thought, well, if I appeal to the appellate court now, are they going to say, well, number one, it's been a lot longer than 72 hours because you only have 72 hours to request an expedited review. It's been a lot longer than 72 hours, so it's stale. Or are they going to say, well, you should have at least let the judge in the Superior Court say why she did it or explain it or something like that. So I didn't want to waste my time. And so on August 3rd, I filed a motion to unseal court exhibits 1 and 2 and for articulation of the January 18th, 2017 orders. And basically I go through in here and I list all the things that Judge Dewey didn't do, all the ways she didn't comply with the practice book. And I cited State versus Patel, the recent case in the appellate court. I also said that this is a matter of public interest. I said, you know what, you may not have articulated the overriding interest that caused you to seal the notice to the prosecuting authority, but I'll articulate my overriding interest and why I filed this motion to begin with. And it's because on December 20, the overriding public interest identified by American News is further supported in the investigation and findings of a Hartford Police Department Internal Affairs Division report dated February 10th. And we didn't have that when we filed the December 2016 motion. The IAD report was prepared by Sergeant Kevin O'Brien, an investigator with the IAD, under the direct supervision of Lieutenant Michael Coates. Now listen carefully. The Crombie law firm represents Lieutenant Coates in the federal civil matter. That's the one that Ed brought for the Park Street and Kelsey Street incidents. The Crombie law firm represents Lieutenant Coates, who is the commander of the HPD IA. And in the report prepared by Lieutenant Coates under his supervision, it was found, based on the preponderance of the evidence, that the investigation discovered sufficient evidence to charge Sergeant Sean Spell with excessive force. So let that sink in. The Crombie law firm is representing Sean Spell in an assault third and breach of peace case related to the June 4th incident. The Crombie law firm is also representing Lieutenant Coates in a civil matter, and Lieutenant Coates found that Sean Spell engaged in excessive force at the June 4th, 2016 incident. Am I the only one that sees a problem with that?
Well, it's crazy, and maybe I'm misreading the whole thing, but if you are an attorney representing your client, the defendant, and you've come up with some witnesses in their behalf, are you as the attorney representing each of those witnesses as well?
What is
See
I
if
don't
I
know.
see if
what's
I
the
can.
Crumbie law firm going to do when the prosecutor calls Lieutenant Coates as a state's witness against Sean Spell?
His
the
client,
Crumbie
yeah.
law firm represents Lieutenant Coates.
Yeah.
Well,
Whose interests are you protecting?
Right.
Right.
Let me see if I can simplify it down to even make it even more simple for the people on the other side of the camera. How does Crumbie represent the person being investigated and the investigator?
Yeah, exactly. That's what I'm
Yes.
saying. Whose interests?
How?
Yes.
Because
Thank you.
Because here's what happens. They have a vested interest in having no findings against their client Sean Spell, or reduced minimal findings against Sean Spell, and they have a vested interest in having Lieutenant Coates address the issue appropriately and give the maximum penalty for anything that happened. For example,
You're making it too complicated now. That wasn't clear.
okay, then let's go back to
I
this.
liked it when you
let's
said
go back
the
to
Crumbie
this.
law firms representing.
How do you represent the police officer who makes the arrest and the person who's arrested?
Well, at first glance, and maybe at second and third glance, it looks like there's an attempt to bring everybody under the same umbrella of one law firm. And isn't that what they used to accuse Bruce Cutler of, and why they threw him out? No, you can't represent all the mobsters and keep them all on one page. No, you're not allowed to do that.
Even co-defendants.
Right. Right. You can't do that.
Yeah. Got me.
Look, and then I'm going to shut up. I'm aware of 2 cases where attorneys have been forced to recuse themselves. One of which is
Well, let's just leave it at this. Why is it in some cases the prosecutor is so quick to point out what he or she believes is a conflict, but in other cases, like Sean Spell's case, where the conflict is so obvious, the prosecutor doesn't point it out? Is it because everybody has an interest in making sure that Sean Spell is the one person who was eligible for retirement and he had nothing to lose? We waited for him to retire, and then we arrest him, and we wait a really long time to let things calm down, and then the June 4th thing just goes away, and everybody like Officer Barone, who has muscle memory about turning dash cams off, and who, says to Officer Boyka, oh, just say he backed into you, not that you rammed into him. Those people just get to keep on going out there on the streets arresting people.
And let me end it with...
It's all one big
little...
cluster.
Let me end it with this. You're right. The prosecutor who's so quick to see a conflict, an ethical problem in one case, is blind to it in another.
Even when you file motions to tell them.
Even when it's the same state's attorney.
Same person. Yeah.
Dave Shepak in Litchfield County.
Right. So what I said was, the Crumbie law firm's representation of Spell as a defendant in a criminal matter and in the federal civil matter. Oh, I forgot to tell you that. They represent him in the criminal matter and the civil matter. And they also represent Lieutenant Coates in the civil matter, and Officer Barone, who was there at the scene, and Officer Vincent Marfella, who was there at the June 4th incident. It just goes on and on. And its contemporaneous representation of HPD officers in the federal civil matter presents an appearance that the Crumbie law firm, which, by the way, is retained by the city of Hartford.
I was going to ask you,
in the civil case, the Crumbie law firm is retained by the city of Hartford
And
to
answers
represent
to the corporation counsel.
the individual defendants. It just looks like it is a conduit for putting an umbrella around everyone involved to keep them on the same page.
Controlling the narrative
Right.
and controlling the situation.
Right.
Now I need to say something.
So thankfully, like I said, I was concerned that if I filed a petition with the appellate court that they would say, more than 72 hours has passed. You should have let the judge articulate something. So I did file this on August 3rd, and today in the mail I received a return of papers form from the court, signed by the assistant clerk, Lauren Himmelstein. And the enclosed motion to unseal court exhibits is returned because I don't have standing to file the motion. Every member of the public has standing, whether you're represented by an attorney, whether you're not, has standing to walk in that courthouse and ask, why are public documents sealed? So you couldn't come up with anything better than that. Practice Book 77-1 gives me the right, because it says any person has the right to go to the appellate court and get expedited review of a sealing order. And here, the clerk is telling me that I don't have standing to file a motion. Yeah, I'm amazed. I'm just amazed by that.
Obviously never read the practice book.
So anyway, so
well, that's crazy.
Ed's now on the phone. Why are we doing, what is that? What is that camera doing that for? Okay, so Ed's on the phone.
All right. Yeah, I was going to say, you know, I don't know where the Hartford Police Union stands on this, but I would think if they have representation and they have an interest in this, if the same attorney is representing
it's the
Sean
same
Spell,
law firm.
Yeah, same law firm was representing Sean Spell, who's a defendant in criminal and civil cases, and they're representing several other police officers. If they're going to testify in his defense, they may actually incriminate themselves and
Right.
make themselves put themselves at jeopardy,
Right.
either civilly or criminally,
Well,
whatever.
there's just so many things that could go wrong.
Yeah, and where's the union? The union should say, whoa, whoa, whoa. Whoa, you're representing the city, that's fine, great, God bless you. We're going to represent these other guys and make sure that they're not going to get in a jam
Well, that's the
testifying
thing.
for or against Sean Spell.
If you have an attorney that's representing somebody else who's kind of involved in the same thing you were, and the attorney's telling you to do something, in the back of your mind you're thinking, is he watching out for the other guy? Is he
Exactly.
watching out for me? Can he be watching out for both? Is that possible? You know, those questions are in your mind. Or is the attorney really looking out for the city? Who's the attorney looking out for?
Well, that's exactly it. If they're a city contractor or something, whatever, working for the corporation council, presumably they're defending the city, the officers, and other witnesses. I don't know how that works. I mean, it's similar to, I guess in very few cases, the same attorney can represent both parties in a divorce case. Generally, that doesn't happen, right?
Well, that what they have now is mediators,
Okay.
that can try to bring people. But when it actually goes to court, the attorney can only file an appearance for one of the parties, and the other party sometimes is just pro se, but it's all understood. Everybody's helping each other, but the attorney can't file official
For
appearance
both.
for both.
Right.
Right.
So how do they do it in this case? I don't know.
And why is it that when it's brought up, everybody wants to seal it? Okay, done with that.
Yeah, it's
Next
crazy.
subject.
Let me go, because the reason I went into master control is there is a photograph that I'm going to want to use in this story. Okay? And I'm going to set it up and I'm going to try and speed through it because we have an 18-minute clip that'll play sometime during the next hour and a half. There is a situation going on in the town of East Haven, Connecticut. It involves a rock quarry operation, and the zoning board of appeals and the mayor's office and the assistant town attorney and the town attorney, the son of the assistant is the, it involves a whole bunch of shit going on. Well, Rachel and I became involved with East Haven over a totally different situation about how they wanted to charge us illegally for a police officer to show up on a subpoena in court. So we knew there were issues in East Haven, but I mean anybody that Googles it will find out East Haven is a entity unto itself when it tries to do their business, whatever they want to do. All right. American News had it brought to our attention that this issue was brewing and it was really a screwed up mess. We were asked if we would cover the Zoning Board of Appeal hearings. We agreed. We went to East Haven. We attended, we recorded, and we have published on our YouTube site the first public hearing night, the second public hearing night, and the third public hearing night. In the meantime, documentation came to American News, and they were the May 9th minutes of the Code Enforcement Committee for the town of East Haven. I was asked, because not only is it American News, but it's, quote, information services, to go to East Haven and acquire the minutes of the Code Enforcement Committee. We went to East Haven. I walked into Town Hall. The first place I go is to the town clerk's office, where minutes are kept. They didn't know what I was talking about, like I had two heads. They pointed to the wall and they said, all of our committees are listed right there on the wall. And I took photographs. And I said, well, I got this one set of minutes here. And they said, oh, that's not a committee, that's a staff meeting. And I said, oh, well, if you're going to call it a staff meeting, don't put on the top Code Committee, Enforcement Committee. Don't call it a committee, just whatever.
Oh, okay.
Now I end up at the mayor's office. They tell me, oh, those minutes would be down in the mayor's office. So I walk into the mayor's office, and there's two young females who are new to employment in the mayor's office. And when I asked them for the minutes of the Code Enforcement Committee meetings, they looked at me like I had two heads. And she looked in her file, and she said, we don't have anything. And I said, well, I've been to the clerk's office. They said, you got to have either a book of minutes or a folder of minutes.
Yeah.
And I was told that they didn't. I said, you have to. And a guy comes out of his office, who's, I guess, the assistant to the mayor, and started to tell me that, no, they don't have any minutes in the mayor's office. The minutes are given to the individual members that attend the meeting. And I said, well, and this went on and on and on. So I got pissed. And I said, look. And he goes, well, why don't you go down to the town attorney's office? And, you know, being a smartass because of the thing with Rachel, I said, and where might that be? He goes, well, his office is down the road on Main Street. I said, in his father's law office, right? Al Zullo and Joe Zullo, the son, are in the same office. Oh. He goes, yeah, that's right. I said, I tried that once before and got locked into horns with the father, you know, because I presented myself at the town attorney's office looking for public records. Not going to do that. I said, why don't you do me a favor? Get him on the phone. And he says, I'm not going to get him on the phone. I said, I'll give you his number. You want him, you call him. I said, give me his number. So I call the younger Zullo, Attorney Zullo, who's the town attorney. He gets on the phone. He's very polite. He knows who I am because of the situation with Rachel and the extra duty hours for police officers on subpoena. And I said to him, I said, Attorney Zullo, you know that I work for Rachel, and you know that I'm with the news media. You know that I'm covering this public hearing. I said, I am not here to burn your town hall to the foundation. I am simply here to access, inspect, and possibly get copies of minutes. If I get them, I'm out of here and I'm going back to Hartford. Now, mind you, the guy that came out of his office said to me, you need to put it in writing and we've got 5 days to get them to you. No, you don't. I don't need to, whatever. I don't give a shit. But that was, he's telling me about FOI. But, FOI would probably agree with him. So the town attorney says to me, Ed, let me call you back in 5 minutes. He calls me back in 5 minutes, and he said, why don't you go in the mayor's office, and they're going to show you the book. Now put the graphic up. This is the photograph that I took of the book where the minutes of the Code Enforcement Committee minutes are kept.
So there is one, uh-huh.
Well, no. The ha-ha moment.
Ed.
The ha-ha moment. So now you got to understand, this is exactly what went through my head. Oh, wow, good. I don't have to come back. Let me get
close up.
Let me get
Nice. Thank you.
Let me get the minutes that I want, and I wanted from January 2015 through present. So, but then all of a sudden,
It's a close up of a document.
But yeah, high definition. So what happened was this: as I'm looking at the book, the two very nice women are standing on the other side of the counter. And I'm feeling bad because I got kind of Ed Peruta-ish in the mayor's office. But that guy that came out is in his office behind the wall. So I did this, and this is exactly what went down. Frank, can I talk to you for a minute? And he came out of his office. And I have probably a very bad habit of pointing. I said, I need to ask you a question. What's that? I said, did you know that this book existed in this office when you told me that it did not? Well, we have to check with the town attorney. Stop. You told me I had to put it in writing. You told me you had 5 days. So you would have wanted me to leave town hall, go all the way back to Central Connecticut, make a request in writing, wait 5 days for the fucking book that's sitting right here on the counter. Well, we have the town attorney. There's nothing exempt from disclosure in this minute book.
Well, if it is, it shouldn't be in there, right? Yeah.
There should be
Now,
redaction or
now,
something.
so I said to him in no uncertain terms, I do not like being lied to by public employees when I ask a very reasonable question. Now, I will go this far. The girl took the minutes, went down to the copy room because she had to unstaple them and copy them. And then I asked Frank, I said, who's this Deneen, whatever her name is? The woman who did the minutes. Oh, she's down in finance now. Could you ask her if she did these minutes in Microsoft Word? And if she kept a file copy in Microsoft Word on her computer? And I guess maybe because of the confrontation, he went in his office, he called down, she said she did, but she had moved from the mayor's office to finance. She came up, she went into the computer, she said, what do you want? I said, what do you got? And she says, well, we've got from 2012 forward. I said, I'll take it all. Put it on a CD and I'll take it all. And she said, okay. So they went down the hall and told the girl that she didn't have to copy the paper copies. We saved the tree. And she gave me a CD. And I said, I'll give you the $1. And they said, nope, we're going to give it to you. So they gave it to me. And I walked out of the East Haven Town Hall with a CD with almost every set of minutes from 2012 through 2017, but the June 20th minutes were missing.
Of 2017?
Of 2017. Which I had to go back down the next day to say, look, I think you forgot something. And
well, but see, that's a human error.
That's a human error.
I can live with stuff like that.
But
as long as it's correct.
But that book, this is what I've been trying to say to the FOI for 40 years. You walk in, you simply want to have access to inspect. It's right there. It's under their nose, and they give you a line of shit that causes all of this going round and round.
Okay,
and
we'll
ends
get
up
back
in here.
to the story.
Okay. Well, that was the story.
That was the story.
That was the
But
story.
we already had the May 2017 minutes, which is what has led to the real story. That's not
in the minutes.
The story. That's
In
like
the minutes.
the background for the story.
I've got 2 clips, but I'm not going to play the first one because it's up on Facebook. It's up on YouTube. It's called "Liar, Liar, Pants on Fire, You Got Caught." Because I was at the meeting where the assistant town attorney who represents ZBA said, I had nothing to do with the quarry issue until the day before the last meeting. Last meeting was on July 13th, which means he's saying he had no involvement until July 12th, but I'm holding on to a set of fucking minutes from May 9th where he's quoted 7 times throughout the meeting, and he's quoted about the quarry, and he's told to write a letter of some kind. And I'm sitting there going, well, that's a lie, because how can you tell the public and your clients that you weren't involved when in fact the minutes say you were? Now it comes to this meeting Thursday night. The quarry's lawyer gets up and says, I have to, and you'll see this, I have to resubmit my concerns over the conflict with the city attorney,
It is another issue of conflict.
With the attorney, because he said that he didn't, when in fact we have minutes that said that he did. Okay? And then...
Not right away, but a little later, the attorney, the assistant town attorney, Al Zullo, responds and gives his explanation.
And he basically says, now you got to understand, you can break stones with, I did not attend or I did not participate. I didn't attend the meeting. I was in Florida. I wasn't even in the state. When in fact, the minutes say that he was the mayor took a roll call and he was attending via phone. Now the FOI does that with prisoners in jail. If a commissioner is sick, the commissioner can participate in the FOI.
I think in the year 2017, everybody knows what a teleconference is.
Yeah. Right.
Yeah,
it's not unusual.
No.
But it was funny the way he said,
how can I participate?
In the minutes it said he participated by phone, and at the meeting he said, how could I have participated? I was in Florida. And I'm thinking,
don't you remember?
But he also
well, no, but they have phones in Florida.
He also specifically says, where in the minutes it said Al, Chris, and somebody were told to work on drafting a letter. And he goes, how can I do that when I'm in Florida? Skype?
Phone call, email? They have all these work...
Office, there's some program out there. Yeah. Conference call.
People are everywhere and work together now. It was
right.
It was the strangest response.
People talk to the federal court.
I can't do work on East Haven matters if I'm not in East Haven.
Rachel, I used to spend 6 months a year in California on a laptop working with you here at the office.
Everybody does now.
Right.
Ask Howard, one of our callers.
There is an 18-minute video clip. And I have to tell you, the managing member of River Farm Rock, LLC, whatever they call it, in East Haven, the one that's really getting the screws put to him, the political screws put to him, made a very impassioned statement, public statement at the public hearing about what's going on with him. And I don't know if we should play it right now. 53.
Well, yeah, it's halfway through.
Yeah. So
Well, what are we going to be seeing? What parts of the hearing did you include in this 18 minutes?
I think it's going to start with the quarry operator's attorney saying, "I have to bring to your attention."
Good. That's a good part.
Okay. I know that you may be upset, but I gotta raise the issue again because the town attorney made a statement that's not true.
He didn't say that. You'll hear what he says, though. And then what comes after
You know, why
that?
should I put words in his mouth when I
No,
got
no, I'm not
videotape?
asking you to say what people said. I'm asking
Oh.
you for what portions
Let
of
me-
the hearing are we going to be looking at
Let
now?
me just what people
said.
just add a couple of things to
Okay.
this. In the part where Attorney Al Zullo is speaking, I want you to pay particular attention to when he says those were handwritten minutes. It was not recorded. The meeting was not recorded. Those were handwritten, meaning they're in error. They're wrong. Okay? And then there were statements made, and this isn't up there, but I'm just going to add it. There were statements made by members of the public where they either said something, you know, like the former zoning officer is working for the library. No, he's not. Some woman
who
said,
cares about what
no,
they
what I'm
said?
saying is
That's not the issue.
the video record shows the truth. So with that, there's an 18, 19 minute
No, but that
tape
is a good point, because the one woman got up and the chairman of the planning and zoning said, "Are you the one that got up at the last meeting and called this whole thing a hoax?"
Oh.
And she said, "No, I didn't say the word hoax," you know, and she
Don't
denied.
put words in my mouth.
And then didn't somebody look at a transcript?
The
because,
attorney
yeah,
for the quarry got up and said, "Wait a minute, from the record,
right,
from the transcript, he said her name, he said her address, and he said this is what her opening statement was, is this all a hoax?"
right.
You know, and she goes, "Oh, did I say that?"
So it's kind of funny that came up, that she had to basically admit, after saying she hadn't used the word, that she did use the word, right after Alzulo said, "I never said that," or "I wasn't there." And by the way, there's no recording of it either.
Well, the issue that I have is this. This is my issue.
See, but what Alzulo has to be worried about is there were like 11 people participating. If any one of them happened to record it on their cell phone, and I find it hard to believe not one of 11 people in this day and age was recording that meeting, he's got that to worry about
But-
if he's not being accurate.
You know, he's not going to get arrested.
No.
But
You know what? You're right. Nothing will happen to him.
nothing. But I have to tell you, it is a perfect example of the tail wagging the dog. In other words, you don't get in trouble for what happened at the Code Enforcement Committee meeting on May 9th. You get in trouble for saying you weren't there.
But listen, and maybe we should save this for after the video, but listen, if the attorney for a planning and zoning, is it a committee, a commission?
Zoning Board of Appeals.
If an attorney for the Zoning Board of Appeals participated with the code enforcement officer in writing and issuing the cease and desist letter that is the subject matter of this hearing, doesn't that seem like a conflict?
Can we play the tape?
Okay.
Play the video clip. And this is East Haven, Thursday night, August 10th.
Mr. Chairman, at the risk of offending everyone again, as I've been told a couple times that I offended everybody, I have to submit to the record and renew my expression of concern regarding Attorney Zullo. At the last hearing on August 3rd, when I raised the question of whether or not he should recuse himself, he indicated on the record that in fact, and I'm quoting, I'm reading from the transcript, in fact, I had no involvement in the quarry file until the day before the last meeting, meaning the hearing we had in July. Attorney Conway provided us with copies of the Code Enforcement Committee minutes of May 9th, 2017, which Assistant Town Attorney Al Zullo participated on regarding Carberry Road. Anyway, Attorney Al Zullo says there's nothing wrong with what had transpired. Al Zullo explains that he sent a letter to Chris Soto and Attorney Joe Zullo explaining that they need to reevaluate this fining system because they don't comply with the statutes in Connecticut. Al Zullo explains that they appealed the notice of violation with the Zoning Board of Appeals. And then finally, and this is what concerns me the most, Mr. Chairman, the final note in the minutes is Al, Joe, Chris will work on a letter. The letter will go out, copy the attorneys on it, and Dee and Sal will bring it to the meeting tonight to show the steps the town is taking on this project. Mr. Chairman, this meeting occurred at 9:30 a.m. on Tuesday, May 9th, and by the end of the day on May 9th, my client was served with another cease and desist order. And it appears to me from the minutes that Attorney Al Zullo, Attorney Joseph Zullo, and Mr. Soto were charged, directed by the mayor, to move forward with the document. It is difficult for me to understand how a person who was involved in the drafting of the cease and desist order can now advise a body sitting de novo as a judicial body as to the propriety of that order. And I submit this. I understand that it's completely your decision. I make no further comment except to say that I am extremely concerned that that's the circumstance. That's a copy of the portion of the transcript and a copy of the minutes of that code enforcement meeting. Mr. Chairman, I'm not asking you to take any action. That's up to the Zoning Board of Appeals. It doesn't matter whether it's on a public hearing or not. Our final comment, and then certainly the public hearing can be closed.
My position hasn't changed. These minutes of these meetings are handwritten and not recorded. I was addressing fine procedure. I indicated there was an appeal here that a fine to apply. And I spoke about a need for us to adopt a hearing procedure for citations number 7-152C, which we did not have anything in place. We had a statute, we did not have a letter, we were not enforcing our fining, we were not doing our fines correctly, and I indicated that I would prepare such a letter for use for hearing citation procedures, not for this court. In fact, we did not prepare a letter for a hearing citation procedure for this court. I have prepared such a letter. We've used it 3 times, but it had nothing to do with this. As to the letter referred to in the last paragraph, I can't tell you how or why that's there because I was in Florida. So there was no way for me to be working on a letter that subsequently went out to the quarry. My only involvement relative to that proceeding was as to the issue of fines, not only with the quarry, I pointed out with all of our zoning violations. So, as I've indicated before, I believe that my involvement previously is next to none. And I was not assigned to this project, and I believe that there is no conflict with me continuing to represent this board, especially now since I've sat through all of the hearings.
is Mr. Patton, Farm River Rock, who's remained silent for doing 9/10 of the hearings, wants the opportunity to speak to the board. And so this is John Patton, Farm River Rock, and 1 Barbara.
Good evening, my name is John Patton, P-A-T-T-O. I'm the managing member of Farm River Rock. In regards to this appeal, the concept is simple. Your previous zoning official made a ruling that we were grandfathered, put it in writing, it was published for the world to see, and yours or anyone else's time to object was back in 2015. If you want to regulate us, it is your responsibility to have regulations that we can meet, not mine. My own observation in 2012 when I first walked the site was there was 2 old rock crushers and screeners that were on their last leg, but they were still functioning. There was barely any room to move because of the hundreds of thousands of yards of site demolition debris that was brought in by a previous owner. I handled that at my expense. A tremendous amount of rock had been blasted and removed from the site. And after working the site for a number of years, I saw that there had been more material removed than even I first believed. I met George Mangione, your retired zoning agent, on the site, who told me that this had always been a quarry and it was grandfathered. We also observed that there was a potential for a viable business here. My former partner and I leased the quarry because despite its issues, it still had potential. We bought the quarry in 2016 because I realized that the letter from Biancourt was as good a legal protection as a quarry owner could get. We took on substantial debt to purchase the equipment instead of renting it and buying the property instead of leasing it. We formed a new business relationship to own and operate the quarry. We tried to be cooperative. In early September of 2015, after approximately 20 blasts, no blasting permits. When I was told this, I called the mayor's office and talked to Sal Brancotti. Mr. Brancotti told me they wanted the quarry issue to lay low because there was some councilman up in our neck of the woods named Sands, and the mayor was trying to placate him. What struck me most about the conversation is that Mr. Brancotti asked, didn't I want the mayor to get reelected, like I cared? I could not answer that question because I was so dumbfounded that my business, my investment, was being held hostage because of the mayor's reelection bid. You can see in the blasting records that we did not blast for nearly a 2-month period between September and November as we scraped up every piece of broken rock that we could use to keep our business going. Also, you can see that we blasted 3 days after the election. We were supposed to be allowed to get the permit the day after the election, but somebody didn't live up to their word. And they were reminded of their promise. So it was the 2nd day we got the permit. I did not raise an issue then because I did not own the property, and out of respect for the landowner, Mr. DeLongo, I cooperated. In February 2017, I met your current zoning agent at the zoning office. He told me he knew of Biancourt's letter. I asked him why he was giving me a cease and desist order on the trees, as they were part of my mining operation. He told me that the cease and desist was only for the trees and not the quarry operation. When I met him on April 25th at the quarry site, we talked about Biancourt's letter, and he said to me that he realized that even though he would have come to a different conclusion than his predecessor, the letter gave me the right to quarry, and it was on me to apply for special exceptions or section not do that. His cease and desist order, stop work order on May 9th to stop all quarry activity was a politically motivated action as I see it. I know this accusation offended Attorney Conway because his client is an Army veteran. And since we're also easily offended, let me tell you that as veteran, I'm offended when people use their veteran status as some sort of shield or buffer for actions that have nothing to do with being in the military. So Attorney Conway, you've never been in the military, but for those of us who have served, we know who we are, we know what we did, and it will always be a part of our life. But it should never be used as an excuse for our actions in life. Attorney Conway made a big show of allegations without proof, and and then handle all of us the written proof in the form of minutes of private meetings of the Mayor's Code Enforcement Committee. Thanks to Attorney Conway, we now know what is really going on. It is important to the Code Enforcement Committee that people under discussion are paying enough property taxes. In July 2014, the Code Enforcement Committee meeting, there was discussion of our, Farm River Rock, our large blasting operation. But most importantly, Mike Malisi is charging taxes on the equipment. Since we successfully contested the property taxes on our manufacturing equipment, we apparently did not fall under that code exemption anymore. It may not have mattered because if we did pay the taxes, in May 9th, 2017 meeting, which you now have in the record, the mayor started off and forcefully stated that he was determined to deprive us of our rights until a court orders the town not to. Because Joe Cafora is building a house up there and he's spearheading a neighborhood opposition group like the Russo Avenue group, which the mayor blames for his 2007 election defeat. Some people would refer to this information contained in these minutes as the smoking gun. Despite all the puffing, let us not lose sight of the fact there was no and is no soil erosion. There is zero evidence of any actual soil erosion that occurred. A berm is in place that is nearly 10 feet high, almost as high as these walls, 15 feet deep and 2,000 feet long. The silt fence was installed behind that. The silt fence and the hay bales are containing water runoff from the top of the berm to the fence, which is about 20 feet. What is happening today is not a question of facts. It is a question of law. We provided you with written testimony from 5 distinguished attorneys specialized in land use. One of them, Judge Fuller, literally wrote the book on land use law in Connecticut. They have told you in clear terms, clearer terms you will ever see, Farm River Rock has a right to quarry, and the cease and desist orders are wrong and illegal. I have a right to quarry, and the town has a right to regulate me. However, the burden is on you, and it is your responsibility to have regulations which I can meet. You have a right to regulate us, but you cannot do so with the regulations you have, not even in a superficial way. There's no ambiguity here, and it should be as plain to your zoning officials and legal counsel as the 10 Commandments are to a priest. Trees were cut down because I needed to take them down to continue the quarry, as is my right. You identified an issue of concern on April 20th, 2017, and we responded immediately by placing berms below the work area. We built berms as a part of mine safety, and that's what we did. When the town wanted more, bigger, better, we gave them more, bigger, better. You now have a 10-foot high berm, 15 feet deep, 2,000 feet around the west and southern perimeter, fully seeded, stabilized, and inspected by a respected engineering firm. When we first met your town engineer on April 25th, he stated he wanted all sorts of plans, blast sequencing, and other information. I met with the engineers from Milo and Broom that day, told them what I needed for the town, and they evaluated the request, prepared a contract amendment to produce the information, mailed it to me, I signed it, and sent it back to them. It took your engineers 6 weeks to come out to the site to just ask for the information. But we were not even given the courtesy of having any time to produce the plans, even though we believed we were under no obligation to do so. The bigger picture is this. Why did the town shut down an existing business, causing millions of dollars of damages, causing the necessity to lay off 6 people, and me to sell off my equipment? I have also now lost my quarry manager. When the quarry starts up again, the business will need to be built up from scratch. Were we shut down because we didn't submit plans fast enough? Because the hay bales weren't close enough? Were we were threatened with possible criminal violations because we didn't submit an application under Section 31? When we told you we could not do that, and we didn't just tell you that, the prior property owner's attorneys told you that. Does any of this make any sense? What rational, reasonable people do this? Why could you not just treat us like professionals? We could have spent all this energy and time and money and manpower on productive endeavors, like working on regulations we could all live with. but now we're stuck in a morass and now you just can't leave. I just don't understand the thinking. When I entered the military service as a young man, I swore an oath to support and defend the Constitution of the United States. Now the Constitution is protecting me. It has guaranteed me rights. And these rights go back even farther, hundreds of years in common laws enumerated in Magna Carta, in Clause 39, in case you're interested. But the town, through Mayor Maturo's Code Enforcement Committee, stripped me of my property without due process, without compensation, and threatened me with criminal prosecution simply because Joe Kafora is building a house and he is spearheading a neighborhood opposition group. Thank you.
Yeah, I don't know how much more time we want to spend on this, but we could go through the minutes from that May meeting piece by piece and contradict, to a certain extent, what Attorney Al Zullo is saying about his involvement in the cease and desist letter to the quarry. But, you know, I want to get on to at least one of Matt's subject matters and not spend the whole show on the quarry.
I am going to be putting up
Yep.
the entire meeting because he references things that aren't in this tape. You know, like they were saying that the code enforcement officer is a veteran and whatever. He goes, just because he was a veteran doesn't mean shit. That's what
Yeah.
John Patton's saying. Mm-hmm. And here's my statement to that. Benedict Arnold is a veteran of the Revolutionary War.
Right.
That doesn't mean when he was in command of West Point he did the right thing. All I'm trying to say is this. The video that we have gathered at their request tells a very remarkable story about dysfunctional government and how they can have animus towards a business, because what they're saying is this. The mayor of West Haven was afraid that he would be criticized by neighborhood groups that formed against the quarry would vote against him in an election, along with others that believe what they say. So he wanted the blasting to stop during the election cycle so that there would be no controversy over blasting, and it would not, the opposition to the quarry would not spread and pour over into the election. That's what John Patton is saying, is that his business lost revenue in support of the mayor's reelection at the mayor's direction.
But then the mayor got reelected, right?
Right.
So why did the cease and desist letter go out after the mayor got elected? I don't understand that.
Because government doesn't know how to get their goddamn vehicle in reverse.
I see. Okay, so I looked at the May 9th Code Enforcement Committee meetings, and at the end of the pertinent paragraph where it talks about it says Al, which is Attorney Al Zullo, Joe will work, Chris Soto will work on a letter. The letter will go out and copy the attorney. Al will bring it to the meeting tonight to show this project. So I went to the East Haven website. I didn't see any mention of it in the town council minutes, but you know, that's another avenue to follow up. Was a letter taken to the town council that meeting that's referenced in these minutes, and was the letter shown to anybody? So anyway, there was a town council meeting that night of the code enforcement. Okay, so what do you got, Matt?
So was everybody in East Haven a liar?
No, I know that's not what we're saying.
Sure, it sure sounds like it.
No,
it's got potential. Yeah, the only thing I wanted to mention about the Fourth Circuit.
Yes, let's talk about that. Let's get on a gun issue.
They've had there have been, you know, several gun issues down the Fourth Circuit. One was the assault weapons ban, magazine ban down out of Maryland.
Did that one get overturned too on en banc, or that one?
Yes.
That one did too.
Right.
Oh.
And they pretty much went along with Shoe versus Malloy from Connecticut, saying that yeah, you can ban any guns you want, totally disregarding Heller and McDonald cases. So in this latest case, a guy who was a felon, an anonymous tip was given to the cops that he was in a car with he was black, well, he was in a car with a white woman, and they said somebody saw him loading a gun. So the cops went up to him, asked him if he had a gun. He didn't answer, and the cops pulled him out and found a gun on him. The trial court said, yep, it's good, anonymous tip, because it's a gun.
It's a
Anonymous
good
tip
stop,
is a
in
good
other
stop,
words.
yeah.
Your motion to suppress is denied.
That's correct.
Yeah.
And then it goes to a three-judge panel of the Fourth Circuit. Three-judge panel says, no, you can't do that. Well,
There was some good language in that decision too. Did you highlight any of it?
Well, there was some here.
Yeah, I mean, it was pretty impassioned, about the
Yeah.
Fourth Amendment and the right to be free of warrantless searches and the level of probable cause and articulable suspicion. So yeah, the three-panel decision was a good decision if you're a Fourth Amendment advocate.
Right, and they said whether the judge said the majority ignored the two key questions, which are whether individuals who carry firearms pose a categorical risk to others and police officers, and whether those individuals give up certain constitutional protections afforded to people who don't carry guns.
Exactly.
And, we've been talking about that for several years. It seems like when guns are involved,
Seems like I've been talking about that for 10 years.
or 10 years, well, yeah, I'm talking about at least 10, but I mean on the show for a few years. If you were talking about drugs, this case would have been thrown out and everybody would have agreed that's fine.
Exactly.
When you're talking about guns, everybody says, whoa, hold on now. Now we take off our Fourth Amendment drug hat and we put on our Fourth Amendment gun hat, and the whole rules change, which, of course, is not right. So he said the biggest concern was that condoning searches based on lawful activity, carrying a gun in a state like West Virginia that allows concealed carry, means cops can search anyone they think has a gun, which would likely mean more minorities would be searched. And they cited several cases, which we put together on the show, and it comes down to a minority issue, and what people are looking at is it's not a Second Amendment issue so much as it's a Fourth Amendment issue.
People are beginning to see that.
Right, but there's a whole line of cases going back many years over various jurisdictions, including the Supreme Court, that says, no, there's no gun exception to stop and frisk requirements of Terry versus Ohio. Mm-hmm. And this court here just ignores all that and says, no, because it's a gun, we think that cops could, search. Now, if they had been particular to this case, maybe it would have made sense, just the facts of this particular case. But they made a sweeping ruling, said, no, if police get an anonymous tip, they can just go up and shake people down. So the gist of the article is that people now want the Supreme Court to review cases like this and come to a definite conclusion on it, because these various circuits just cannot keep going in contravention to the Constitution and well-established law and decisions by the courts. So basically what we're talking about too is the problem of you've got the government under Donald Trump supporting this decision, because people heard him talk about law and order to cops and everything. And the government, the Solicitor General's office, I guess, is saying, no, we want to be able to stop and frisk anybody we think has a gun. Okay, not even have any reasonable articulable suspicion. And this is brought together in a team, the other side, gun owners groups, the ACLU is involved.
Yeah, it does make some strange,
civil rights organizations.
Right.
Yeah, so there's a lot of people, and even a bunch of police chiefs and attorney generals from red states, conservative states, are saying, whoa, back off, Trump and Sessions. We're not talking here about guns, no matter what you think. Now, Donald Trump said, oh yeah, the Second Amendment is safe with me. And probably is. But how safe is it when you can say, well, the cops can just shake people down? So now it goes the other way. They wouldn't allow it in drug cases, but they're allowing it in firearms cases. So now, if the police figure, geez, those scumbags over there, they look like they might be dealing drugs. I think one of them might have a gun. Now you shake them down, you find drugs. There's your in to take the drugs, apparently.
Or how about all the circumstances you don't hear about where they stop somebody, search them, find nothing, and then obviously you just let them go. Now, all those people do not file civil lawsuits.
Oh,
they
no.
just go away. And it's kind of like what you were talking about with Officer Barone not calling in his stop to dispatch. How many
Excuse the
cars do you
numbers.
stop and you just call in the good ones where you actually find something?
So those stops don't exist. And that was the point of some legislative discussion this year about mandating police to start recording. There's already a law about them recording traffic stops as far as minorities. They have to get the age and sex and race and stuff of the person stopped. Well, apparently they found out that police were stopping people on foot. They were motor vehicle stops. Therefore, they didn't really have to call them in, and there were no statistics being kept because there was no requirement. So, rightly or wrongly, I don't know, the legislature is saying, wait a minute, you're covering up harassing all kinds of minorities on the street, and probably gun owners too, if they're not in a vehicle and you're not calling in a vehicle stop. So they wanted to bring this within the ambit of that requirement, that statute, saying, all right, we want to know all the police interactions with minorities.
Oh.
If there's, if
That's
there's...
overwhelming.
Well,
That's an overwhelming
it is.
thought because...
Well, it's the slippery slope, Rachel.
But when you think about it, stopping somebody in a car is a discrete action. It's obvious when you're pulling somebody over. If I'm just a cop walking down the street, does that mean if I say hi to somebody, I got to write down there?
No.
If I stop and talk and say, hey, I saw your mom the other day, and we have a conversation, I have to write that down. That seems more overwhelming to me.
Well, I mean, if it's going to be an incident number or something, where you're on foot doing something, like even you go to a house and
Right.
you're confronting somebody.
Right, that...
So, I mean, that narrowed, yeah. It wouldn't
Yeah.
be every time you talk to somebody.
Exactly. Hey, we have a caller, Ed.
You do have a caller, so I'm wondering, then if they move to introduce legislation that requires them to start keeping tabs on the number of total stops, wouldn't it seem reasonable that at the end of each quarterly period or whatever, if the police officers start to see that they're kind of falling behind in their numbers, aren't they then going to tell everybody on the squad, hey, make sure for the next week you got to pull over to white soccer moms?
To even it up?
Yeah.
Yeah, I thought about that too. I did think
Yeah,
about that.
you can play with the stats that way, sure.
I need. Well, the caller is correct.
Yeah, you can play with those statistics and
You know,
get the
Harvard,
numbers where you want them.
and that's evident in the fact that Harvard University was being accused of discrimination in their acceptance policies. So what they did was this year they say that their minority enrollment will exceed their, what do you call a non-minority enrollment? And what they're going to do is they're going to start to enroll minorities to to bring the numbers back in line.
Yeah.
But the question is, do the best candidates get into Harvard?
Well, that argument, I can't stand
Okay,
that
no,
argument.
okay. Well, I know.
Did the best candidates ever get into Harvard? I mean, the relative...
Who's your daddy?
Yeah, the Kennedys. I mean, was every Kennedy that ever went to Harvard, what you think? I don't know. A lot of people get into Harvard a lot of different ways.
But let me.
Donors.
Okay.
Yeah.
So,
donors.
caller, you got any more?
No, that's it.
Sounds
Okay.
Sounds like it's windy there where the caller
Okay.
is. Must be out in North Dakota.
Okay. Now
Bye.
let me just say something. Let me just say something because you talked about. Matt said they now want you to record every stop/contact, whether you're in a vehicle or on foot, so that you get a better representation of what's going on out there. Now, you said that would be unmanageable.
Well, it seems a little overwhelming.
Okay. And these cases, like you said, 1,000 people can get stopped on foot, or 1,000 people can get stopped by Officer Barone, who doesn't call it in, and those numbers never get put into the total numbers. So the numbers you look at are skewed, and the number, his intuition is sharpened in the statistically that, boy, every time he pulls somebody over, he has a sixth sense. No, he doesn't. He just makes a lot of stops. But I need to say something. And it's going to sound funny the way it comes out. I think that you can make a reasonable, unreasonable stop. Or an unreasonable stop in some cases can be reasonable. And what I'm saying is this. There is in every good officer a gut instinct and a gut feeling that there's something about what they're looking at that triggers their need to pull somebody over, to stop somebody, to frisk somebody. And it may be something so minor as body language, a hesitation, a looking away, a diverting, trying to not be seen.
Pretty much how everybody acts when they're stopped by the police. But anyway, go ahead.
No, what I'm saying is, it is only when reasonable unreasonableness begins to become widespread that someone who normally just fluffed it off and walked away says, I've had enough, I'm going to get a lawyer, I'm going to address it, and then all of a sudden it finds its way into a district court, a court of appeals, or the Supreme Court, and you come out with a Terry v. Ohio decision. You come out with a Miranda decision.
Are you working up to my new consent theory?
No. I'm going to tell you right now that John Grisham wrote a book called The Pelican Brief. And the whole theory of the book was there were a lot of people in Washington getting killed in the Supreme Court and whatever, and nobody could figure out why until someone found out that there was a case involving oil fields in Louisiana that was at the district court level that they knew was going to find its way to the Supreme Court, so they wanted to get the Supreme Court stacked in anticipation of that case coming up.
Did you read the book or see the movie?
Both.
Okay.
Now, Rachel has filed in the Kaminsky case a response? Rebuttal?
The state defendants, the two police officers, the two state troopers from the firearms unit that went to Mr. Kaminsky's house on December 16, 2011, filed a motion for summary judgment saying to the judge, you need to dismiss this case, we didn't do anything wrong, qualified immunity, whatever.
Because we knocked and talked.
Yeah, because the homeowner consented to our entry.
Well, I have to tell you, and if you've got, do you have
it right here?
Okay, I want you to read so the people on the other side of the camera can hear what I believe is something very easy to understand. And to set it up, it goes like this. When government applies for and receives a warrant to search or to seize, arrest, search, or seize, there's a lot of safeguards built in that the officer's not he's got somebody else that agrees with him.
He's got to write it out and think about it.
And if the warrant gets rejected, the person who was going to be arrested or the property owner where there was going to be a search and seizure is protected because somebody stood between my house and the officer.
The warrant requirement.
Right.
Under the Fourth Amendment.
Right.
That's the default method, the warrant. But the exceptions have overtaken the default.
And now you have to, because we don't have it, we have it on video, but we can't show it. We have Detective Barbara Mattson in a deposition explaining to Rachel after questioning,
Oops, that's not it.
I don't really need a warrant because I can just walk up to the door, introduce myself, ask to come in.
Well, let me tell you what she said exactly. She said, let me find the place.
It's your show right now.
No, I don't want it to be my show. I want us to have a discussion. I don't like it when you do that. Let me find this place.
Okay, while you're looking. Joe Kaminsky had law enforcement approach and come to his door
Okay, I'm ready.
on the belief that he was a convicted felon when he was not, and they seized his firearms because of their belief that he was a convicted felon, and they did not have a warrant. And I know that they had more than enough time to apply for it, to have it reviewed, to have it signed or rejected.
Okay, so this is what Matson said in her deposition, that before they went to Kaminsky's property, there was no discussion about what would happen if Kaminsky did not consent to entry to his home. No discussion about the potential of needing to get a search warrant. And this is a man who they thought, mistakenly it turns out, was a felon with at least two machine guns. And it turned out he actually had 59 firearms in his house. But they didn't make any plan or talk at all about the potential for needing a search warrant. She testified that during her 15 years with the state police, she has always been let in. There was no discussion about the possibility of applying for a search warrant. There were no preparations for the contingency if a search warrant was required due to lack of consent. Matson could not recall any specific instance of a CSP, a state police officer, knocking on a door and not gaining consent to enter. Doesn't that make you question whether consent is really freely given?
Because
she said she never had to use a warrant to gain entry into somebody's house to seize their property.
Barbara Matson, usually dressed in a pair of slacks, a shirt, and always had a sidearm on her hip. Now, I will tell you this. As law-abiding citizens that have no fear of law enforcement because we've done nothing wrong, there's something about 4 or 5 people on your front step all wearing guns and badges, and you're going to say to them, "Get the fuck off my front step and get away from my house. I don't want you here." No, you cannot come in my house. There's something that we have the fear of saying, "No, you can't," to an officer.
I mean, people are like sitting ducks when the cops show up their house. They're
Okay,
afraid.
now,
They don't know what to do.
I don't want to run out of time. I want you to read
I
what you wrote.
Ed, let me go through it some more.
Okay.
So, what I said, the theory in this, and help me explain it, Ed, because I kind of came up with it.
Oh.
A warrant process includes the review of the affidavits in support of the warrant.
The facts.
A prosecutor reviews the warrant, and if there are errors or corrections or it's not substantial enough, the cop's told to go back to the drawing board, do some further investigation.
You don't have enough.
What we used to run into in Hartford a lot when we were reviewing warrants, especially for the cops from the Vice and Narcotics Squad, was, you haven't clearly identified the door or the property that you want to gain entry into. Is there a number on the door? What's the color of the door? Is it, facing south, facing north? Identify where you want to get into. That's like number one. And sometimes it's not so easy. So these are things that the warrant review process accomplishes. It prevents cops from going in the wrong door. which can really be serious sometimes and can
People
result
get
in
killed.
injury. That's right.
Police officers have been killed going in the wrong door.
Now, the issue in this case was Mr. Kaminsky was convicted in 1964, didn't pop up until 2011, and by the time it popped up in 2011, and Matt Tyszkka did this research, this crime had become a felony under that statute number. Well, when Mr. Kaminsky was convicted of it 47 years prior, it wasn't a felony. Did anybody bother to check? No, because Barbara Mattson took it upon herself just to get the word and rush out there. If a lawyer would have looked at this, that's obvious to a lawyer. A conviction that old, you got to look at the legislative history and figure out statutes change a lot over time. And a lawyer, a prosecutor would have looked at that, a judge would have looked at that, and they would have never made it to Mr. Kaminsky's house. I submit to you, if a prosecutor and a judge had looked at a warrant, they never would have gotten authorization to go to his house. And all this time and heartache over the past, since 2011, would have been saved. I also put in here, and this has been an idea of Ed's for a long time, Mattson testified that when she got word, she traveled from Middletown to the Coventry Police Department before going to Mr. Kaminsky's house. Along the way, she passed a courthouse in Middletown at 1 Court Street. She passed 5 courthouses in Hartford, 101 Lafayette, 95 Washington, 90 Washington, 80 Washington Street, and the other courthouse that she passed is actually in Manchester at 410 Center Street. She passed 2 courthouses in Tolland, 69 Brooklyn Street and 20 Park Street. So for a total 5, 6, 7, 8 courthouses she passed, where if she would have walked in there and said, I know of a felon that has machine guns, can you look at this warrant?
We're on the way to the
I would have
house.
found something.
Oh, please, go to those courthouses and see how many judges and prosecutors are available.
We have reason to believe.
Available.
We have reason to believe that one of the FBI's 10 most wanted individuals is at a certain address. Would you please give us the warrant? We're en route there right now.
Well, that's not the case in this case.
No, it's not.
Yeah.
But I'm just saying, the process is they walk in the door and it's an expedited. They're not told to wait 2 hours. The prosecutor, if there's one available, looks at the warrant. They go right into the prosecutor's office. Prosecutor looks at the warrant, reads it over, evaluates it.
Cops, man, tell me if I'm wrong. Cops, when they walk into a prosecutor's office and have a warrant to take up to a judge, I mean, a lot of times they just submit them in a pile to go through them as you go through them.
The routine ones.
Yeah, but the search warrants especially, where time is of the essence, you don't want the information to go stale. Of course, in this case, there was no chance of that, but they walk right in. They're treated like royalty. Cops, when they show up in prosecutor's office, you put your papers aside. My God, there's 2 cops here. I'm going to look at his warrant. I'm going to escort him up to the judge. The judge is there to look at it. That's what you do.
I'm going to explain it to the judge in their behalf. If the judge wants to ask them questions,
you got all
he
the
can ask,
inspectors and the
and the judge is
investigators
going to sign
hanging
off
out at
on
the
it.
state's attorney's office, ready to assist in any way they can. There's no excuse. There's no excuse. Well, this is the excuse. See, you're supposed to get a warrant, but there's exceptions. There's the exigency exception, there's the consent exception, there's the emergency aid, the incident to arrest, but those are exceptions. What has occurred in our Fourth Amendment law is consent. It's become an either or. It's become get a warrant or have them consent. No, it's supposed to be get a warrant, and consent is the exception to the warrant. But it's turned into, as Barbara Mattson made clear, I get consent every time. Who needs a warrant?
I don't need to get a warrant.
Everybody consents. Okay, and so I'm trying to make a case in here. If you think about it, when there are exigent circumstances or a search is conducted incident to arrest, or a cop needs to get in because of emergency aid, those are all circumstances that are what they are. The cop doesn't create them. Those are circumstances that are there, and so there's an exception to the warrant requirement so the cop can react to a situation that's there. The situation of consent is different. The cop creates that situation. That's not an emergency. It's not exigent. The cop creates it. And what I say, and I'm going to skip to the chase, in using the consent exception, as the default method of seizing property, rather than a warrant to ensure the orderly and lawful seizure of the property, the need to manipulate the circumstances to obtain entry so a seizure will later be found to be consensual becomes a game that the law enforcement officer usually wins based on his or her experience and the trusting nature that most citizens have in law enforcement until they're faced with the situation that Kaminsky faced at his back door. In other words, when we get into this area of consent and we start using that as an alternative to the warrant requirement, cops are so much better at it. They're so much more experienced at it. They know how to play the game and get a person's consent, especially the most vulnerable of citizens. And by vulnerable, I mean the ones who are most easily exploited by law enforcement, which are the law-abiding people who respect the police. They're like sitting ducks when cops show up at their house and try to get consent. Ironically, it's probably your most hardened criminals and your people that are most familiar with the criminal justice system that are going to be the least likely to give consent. So let's just pick out law-abiding people and let's take advantage of that. Let's just take advantage of them like happened with Mr. Kaminsky. And so I think we need to change our law. I think we need to change our case law. I think we need to have statutes on the books where cops aren't allowed to abuse the trust of people they serve by gaining their trust and getting consent to them. People should know what they're consenting to. They should know what their rights are, and we should start having a warning before people give consent, similar to Miranda. When they show up at your door, they should say, you know, you have the right not to consent. If you do consent and we walk in there and we find something, you could be arrested and it could be held against you. We could seize it and you could never get it back.
Anything in plain view.
Now, do you consent? There should be a Miranda warning for consensual entries.
Okay, now, there are two things that I think I forgot the first one, but this is what intrigues me. And we discussed this previously. Associate Supreme Court Justice Gorsuch penned a dissent in a 10th Circuit Court of Appeals opinion regarding knock and talk. And
I was inspired by him to a certain extent.
He's good.
Judge Gorsuch has identified what he considers to be a bad area of the law that needs to be addressed. That law enforcement is more and more relying upon whether you did get consent or you didn't. If there's no body camera, there's no surveillance cameras, there's no audio, all we have to do is say, he consented.
Why is it back in the day, and I think some people still go along with this, oh, I don't like to see open carry because it intimidates me. Well, how about 5 cops showing up at your door? Each of them has a gun. Is that a little
open
intimidating?
Carry.
But no, it's not coercive. You know, courts find continuously it's not coercive when 5 people with a gun show up at your door and want to come in.
So what I said...
And they won't let the cops carry a gun when they're testifying on the stand.
Right.
Well, in some courts they do.
Some courts
they
do.
So Matt, what I said to Rachel was this. Using John Grissom's storyline of the Pelican Brief, Joe Kaminsky's issue, where they chose tactically to ignore the warrant. They chose. They were going out there to seize firearms. They were going out there without a warrant. That was their decision. It's going to go to a district court decision. Let's say the district court throws it out. Well, then Rachel's going to have to make the trip down to New York and talk to the Second Circuit Court of Appeals, to a 3-judge panel. And let's say the 3-judge panel throws it out. Or the 3-judge panel agrees with Rachel, and then they go en banc and overturn it. But the Second Circuit approves this way of searching and seizing for property. 2017, the district court makes a decision. late 18, sometime in 19, the Second Circuit makes a decision. Sometime in 20 or 21, the Supreme Court has an opportunity to read Rachel's statement, read her theory, read what she's saying, and someone like Justice Gorsuch, who will probably have a couple of more conservative justices to side with him, is going to take his theory in the dissent of the 10th Circuit and say, it's time to address this issue.
Let's talk about the gun buyback.
Let's do it.
Let's do it.
Well, just finishing up on what you were saying, you beat me to it, because I was going to bring up the Miranda
Really?
as well.
I'm
Yeah.
wondering, there's got to be a law review article out there that talks about that.
Well, I'm sure there's more than one.
Yeah.
Because, I mean, if you don't get... people confess even in the face of their Miranda warnings.
They
You
do.
know, they do anyway.
They do. Well,
But at least they have the opportunity to say no.
exactly.
And in Joe's case, looking at it in hindsight, Joe should have said, no, you're not coming in. Okay, assuming he wasn't intimidated. I think he was just trying to be cooperative. But he should have said, no, you're not coming in until you get a warrant. And then you go make him go get a warrant. Now, I know from personal experience that on nights and weekends and holidays, there have been requests for warrants. We'll go to a prosecutor's house.
Oh.
They will call the judge, make sure there's a judge available home,
Yep.
sign it, and then you go over to the judge's house, they look at it, and they'll sign
You know,
it
man,
there.
I think they actually have now like warrant duty for off hours and stuff. You know, people that are
Somebody on call.
right.
Yeah.
Yep.
So, there's no excuse for that, and you do that in major crimes as well. If you have a major crime and you need to go search something, you can't wait till Monday morning. You will go and get the warrant. So there was no exigent circumstances, as
None.
you mentioned. This guy had an FFL for probably, 22 years or something?
40.
Or 40
Well,
years?
he had the
from
permit-
71
Had
to...
the permit. He had the permit since the 60s, I think.
Just to let you know, there's no question about exigent circumstances.
Yeah.
Because I had questioned Mattson about what she would have done if he wasn't home. We would have, maybe gone back the next day. When we were in the
If we were in the neighborhood.
If we were in the neighborhood, we would have gone back. That's not exigent.
No. No.
In other words, anything but get a warrant.
Right.
We would have done anything but get a warrant. Even if we had to wait days, we would have let somebody who we think is a felon with firearms, rather than get a warrant, we would have just waited them out.
Well, and that's the lesson to be learned for the people watching is if cops come to the door and they just want you to voluntarily consent to give up your property that you lawfully held. Firearms are lawful property. They're in your home. You don't need a permit for them in your home. Just tell them no, that you need a warrant. And if they come back with a warrant, then okay, you submit to the warrant and let the whole thing take its course. But the minute you do give consent, even in a car, if you give a consent to a search of your car, you're pretty much done. The courts are not going to back you up unless you can show real intimidation. But if you say, geez, I was afraid to say no,
That's not
they're
good
not going
enough.
to buy it.
That's not good enough.
No.
And
So-
you don't really, you don't really even have to give consent. You just have to not give consent. If that made sense.
You have to
Yeah.
object.
Right.
You
And
have
that's-
to stand your ground.
Yeah.
Right, we've talked about that in the interrogation sense, is that if you get arrested, they give you the Miranda warnings. If you stay silent, they can start, pummeling you with questions and all that. You have to get them to stop or not start in the first place. You have to say, no, I want a lawyer. You cannot just stay quiet and assume that they know that you're not going to talk. You have to tell them you are not going to talk. You have to tell them that you want a lawyer.
I believe there's even cases out there where people say, "Should I get a lawyer?" and that's not good enough.
Well, if you ask the cops, they're going to say no.
Yeah, even saying "Should I get a lawyer" isn't enough to.
I
assert
want
your right.
an attorney.
Right.
Yeah. Be very short, declarative sentence. Just be very direct about it, polite and everything. Just say no.
Exactly.
So you have to be careful and you have to think. I know it's emotional if you get arrested, especially in a lot of circumstances. If you're emotional, you're not thinking clearly, you're distracted, whatever, you're nervous. That may not come to mind, but you should rehearse this ahead of time. If you are arrested for something and they start interrogating you, just make sure you state your rights clear, even if they don't give you Miranda rights, because they'll start questioning you before you're in custody sometime.
Yeah.
You know, I just have to give them the rights.
You have to just say, even before they start, say, I want a lawyer, I'm not speaking with you.
Your Miranda idea is great, but or the Kaminsky warning.
Oh, the Kaminsky.
The Kaminsky warning.
Oh my God.
But let me go this far, okay? If I have, because I'm well known in Rocky Hill, I know a lot of the policemen in Rocky Hill. If a policeman comes up to my door and doesn't say exactly why he's there, and say, "Dad, do you mind if I come in for a minute?" Even I, knowing what I know, would probably say, "Yeah, come on in."
I know, we're like sitting ducks.
Okay, no. You see, because I'm under the impression that I've done nothing wrong. Maybe he needs to use the phone. Maybe he needs to use the bathroom. Could I come in? Yeah, okay. But I'll tell you, I have this saying that people have heard me say it for years. Am I in trouble? People call me on the phone and says, "Is this Ed Peruta?" And the first thing I say is, "Am I in trouble?" So I think the first thing you have to ask an officer when he's at your door or he's at the side of the car is this: does this have anything to do with crime, criminal? Is this criminal in nature? I need to know why you're here.
Yeah, I would just say why, because then when you're in court, facing that murder charge, the cop's going to get up there and say, "Well, I got to his door and the first thing he said to me is, 'Are you here about a crime?'" And the jury's going to be like, "Oh,
he knew that he committed a crime."
He did it.
Yeah.
So anything,
all right, listen.
anything you say is dangerous.
We have to.
I want to talk about the gun buyback because I got
well,
ideas.
Talk about it because I got
okay,
I can make this fit. I can make this fit.
No, I just, man, I don't know if I've discussed with you my idea if I were to run for office would be if we're trying to get guns off the street by buying them, there's drugs out there that hurt people as well. I think police departments should start buying the drugs from people off the street.
Well, while we're coming,
it'll do us much good.
Yeah.
While we're coming up with ideas?
No, we're going to sign out, Ed, because everything's too rushed in commotion right now.
This
we'll
won't
pick
take
up
long.
next week.
10 seconds.
Okay.
Evidently, there was a news broadcast where there was a pornographic video showing in the background.
I heard, yeah.
Do you think we could get more subscribers, viewers, and likes if we did the same thing?
Well, and with that, here we go. Let's move on to next week.
The weather girl.
Oh, Jesus. The weather girl. Yeah, we need a weather girl.
Have a good week, folks. Thanks for watching.
Take it easy. Stay safe.